What happens if you violate a trust? If you're serving as a trustee of a trust, you have many essential duties to fulfill. One of these responsibilities is to uphold the terms of that trust. Another is to discharge your obligations under the law. If you violate the law or fail to uphold the terms of a trust in any way, it's likely going to be considered a breach of trust. When a breach of trust occurs, a probate court can impose some serious consequences and penalties, including suspension or removal as trustee, or being surcharged, probate speak for being ordered to pay money, for damages caused by the breach. In rare and extreme cases, trustees can even face criminal charges. For these reasons, trustees should always take tremendous care to fulfill their duties fully and ethically. Of course, understanding your responsibilities under the law and adhering to the terms of the trust are going to be the first steps in helping you avoid these potentially severe repercussions. If you have any questions, schedule a free consultation on our website at rmolawyers.com. How long does a beneficiary have to sue a trustee for breach of trust? Under California law, a beneficiary has 3 years from when they knew or should have known about the breach to sue the trustee for breach of trust, although that deadline may be shortened to 180 days if an accounting is provided that sets forth that deadline. These aren't issues that you should take on your own. You should consult a trust litigation attorney to make sure you haven't blown a deadline. So when does a breach of trust occur? A breach of trust happens whenever a trustee engages in intentional or negligent conduct that harms trust assets or trust beneficiaries. As a trustee, you have a broad range of legal duties, and if you fail to discharge those duties and that failure causes harm, you may be exposing yourself to a lawsuit for breach of trust. The deadline for a beneficiary to file a claim for breach of trust, often referred to legally as the statute of limitations, is going to vary between states. Whatever the time frame, 3 years, 180 days, or some other time, it's essential to remember that the statute of limitations does not start running until you put somebody on notice with an accounting or other disclosure from the time that that breach becomes apparent, which can be a long time from when the breach actually occurred. How do you prove breach of trust or defend a breach of trust claim? Under the California Probate Code, breach of trust occurs when a trustee fails to meet one of their legal duties. For example, if a trustee fails to follow the law, the terms of the trust, or act in the beneficiary's best interest, there may be a claim for breach of trust. Trustees can also commit a breach if they commingle trust assets with their personal funds or use trust assets to benefit themselves or anyone other than the trust beneficiaries. If a trustee has violated one or more of their duties, a beneficiary or another trustee can file a petition asking the probate court to suspend or remove the trustee and surcharge them for any harm they caused. The burden of proof in these cases is going to be on the person who claims the breach. That person is going to be a petitioner in the probate court. This means that the petitioner is going to have to present sufficient evidence to show that the trustee failed to discharge their duties. Sometimes a trust accounting alone will provide enough evidence to establish a breach. However, if an accounting alone does not carry that burden, then the petitioner and the trustee, who's going to be the respondent in most cases, can request additional documents and information from each other, as well as other third parties, in what's known as discovery. The type of evidence that's going to be needed is going to vary on the circumstances of each case. For example, bank statements, investment account statements, real estate sale documents, purchase escrow, closing documents, etc., might prove or disprove whether trust funds have been misappropriated or commingled, for example. Can a trustee go to jail for stealing from a trust? Yeah, a trustee can go to jail for stealing from a trust. The reality, however, is that this is only going to occur if they're convicted of a crime in a criminal court. Under California law, stealing trust assets with a value of $950 or less is going to be a misdemeanor with a maximum jail sentence of 6 months. Embezzling trust assets worth more than $950 is going to be considered felony embezzlement, which can lead a trustee to a sentence of 3 years. Under extraordinary circumstances, trustees can also be charged with other criminal offenses. The reality in these cases, in most cases, is that trustee thefts are going to be handled civilly, not in the criminal courts, but in the probate court. Generally, police officers, district attorneys don't have the resources to pursue criminal charges in these kinds of cases. They consider these crimes to be civil disputes. So if a beneficiary alleges a trustee is stealing from a trust, that theft is usually going to be resolved in the probate court with the help of a trust litigation attorney. When should I contact a trust litigation attorney? Whether you're a trustee being accused of breach of trust or a beneficiary who believes a trustee has engaged in misconduct, you should contact a trust litigation attorney as soon as an issue arises. Breach of trust cases are legally complex on both sides, and no matter your role in the case, an experienced trust litigation lawyer can help you gather and present the evidence you need to succeed in pursuing or defending a breach of fiduciary duty claim. Have questions? Visit our website, schedule a free consultation. At RMO, we protect you and your family's legacy. Thanks for watching.